The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon, and welcome to the Court of Appeals. My name is John Tyson. Joining me today on the panel is Judge Hunter Murphy and Judge Toby Hampson. We have one case on the docket today to be argued in the matter of K&S. Before we get started, are there any preliminary issues that we resolve before we hear from the appellant? Okay, hearing none.
Not for me, Your Honor.
Okay, thank you. Hearing none, we will hear from the appellant. Mr. Diepenbrock, is that the way you pronounce your name, sir?
It is. Thank you, Your Honor.
Okay.
So may it please the court, Judges Tyson, Murphy, and Hampson. I am J. Thomas Diepenbrock from the Buncombe County Bar, and I represent appellant respondent Mother Kayla Jeffcoat. We respectfully request this court vacate the permanency planning order at issue, which eliminated reunification with respondent mother as either a primary or secondary plan and cease reunification efforts, and remand to the trial court for the resumption of reunification efforts. In the subject order, in finding number 21, the trial court found that respondent mother has been compliant with the department's recommendations. She has exhibited an ability to care for the juveniles during supervised and unsupervised visitations. This finding is consistent with the evidence and history in the case, with findings in prior orders, and with the evidentiary findings. The totality of the evidence, the evidentiary findings of fact and circumstances support this finding of fact. This case asks the question, when a mother is engaged with DSS, the guardian ad litem, and the court, is complying with her case plan and is demonstrating a strong ability to parent in both supervised and unsupervised visitations, can a trial court eliminate reunification as a permanent plan and cease reunification efforts? There's a strong public policy, as the court and your honors are aware, favoring reunification of children with their parents. This policy is reflected in the stated purposes and policies of the juvenile code, including standards for interpretation, including returning juveniles to their homes after removal, consistent with preventing unnecessary or inappropriate separation of juveniles from their parents. This policy favoring reunification is reflected in the statutes governing permanency planning hearings, which require reunification to continue as a permanent plan, for efforts to reunify children with their parents to continue unless the court makes findings that such efforts would clearly be unsuccessful or inconsistent with the children's health or safety and need for a safe permanent home within a reasonable period of time.
Mr. Diepenbrock, if I can interrupt you just briefly with a couple of questions. It seems to me that in part here, and obviously you are here representing respondent mother, but it seems to me in part there's sort of two narratives at issue in this case. On one hand, you have the narrative of respondent mother, who appears to be compliant with the case plan. Visitations with the children are apparently proper, suitable, go well. The other narrative, though, is that of respondent father, who appears to be lagging in his progress to the case plan. So would you agree with me that one of the things the trial court here is struggling with is those competing narratives, right? And so it's trying to look at the totality of the juvenile's relationships with both respondent mother and respondent father, who at least at the time of this hearing continue to reside together. And is trying to come up with a way to weigh those sort of competing narratives ultimately in the best interest of the children involved in this case. I'll leave it there and let you kind of speak to that. I have a sort of follow-up question related to that on sort of remedy that you're seeking.
Well, Your Honor, I was going to address that. I think that it's important to recognize that from the outset of the case and from the time of the dispositional hearing and before, the mother and the father were a couple, and they were working a case plan together. They were living together. They were visiting together. They were taking parenting classes. They were taking couples counseling, and all of that was part of their case plan. It was contemplated, and that they were together. And it was never spelled out in advance or stated, look, respondent mother, you're going to have to separate from respondent father if you're going to be successful at reunifying. So it doesn't seem to be a fair result either for the parents or the children for a case plan to and the efforts to comply with the case plan to just go forward and without, and then at the end, or at some point it's like, well, it's impossible. You're not going to be able to reunify unless you separate from the father of your children. So and at the end, at the hearing, respondent mother indicated and stated that she had decided that at that moment she was going to separate from the father and obtain independent housing. So yes, there are two competing narratives, but I think, and the other aspect of it is that respondent mother really needs to be treated individually, and she she was kind of lumped in with the father, and lost out from in the court's resolution of the issue.
Naturally, that leads very nicely into my follow-up question, which is, I noticed in your intro to this argument, the requested relief was to vacate the cessation of reunification with respondent mother. But of course, this permanency planning order ceases reunification efforts as to both parents, and so from a remedy perspective here, are we in a position of having to vacate? I mean, assuming we agree with your position, would we be in a position of having to vacate the order in whole as it relates to both parents, or are you simply seeking, or is there a method for us to vacate simply as to, I guess, poor choice of words under 7B law, but as to respondent mother?
I think the court can. I mean, we're really asking the court to vacate and remand with specific direction of the trial court to to resume reunification efforts with the mother, and I think that the court can give that guidance to the trial court. And I mean, the trial court will have to decide where the father fits in, what's happened since this hearing in question, etc. But I do think that the court can direct resumption of efforts with the mother, given her compliance, demonstrated parenting ability, as we have described.
One of the questions I've had with the argument, and I'm kind of understanding where you're coming from with the past case plan, the directions to the mother, that nothing was ever clear that she's supposed to not be with the father. And I agree that it would be a mistake to kind of switch that up on her right here at this hearing, and then no more efforts need to be made. But how much of this is a credibility issue with the mother when every case plan, everything is said, hey, I'm going to stay with the father, then all of a sudden she's getting up and testifying that I'm trying to get away from the father all of a sudden? How does that weigh into our overall analysis that there seems to be this little inherent change in her position in relation to doing what the case plan says? If we say, yeah, the case plan says you and dad keep working to trying to get the kids back, you grow as a family, you're getting family counseling, you're getting attachment counseling, you're doing a good job of trying to teach dad what he needs to do as well. But where does this credibility change that now all of a sudden when she gets up to testify this hearing, how do we look at that on appeal if there is a credibility issue with her kind of changing course in her testimony that now she's looking for a new place, which is what DSS is wanting?
I'm not sure the trial court made any findings about credibility. I've looked at this order again and again, but I don't believe there's any specific findings in the order that the trial court did not find her credible. And it's clearly not the province of this court to make judgments about credibility.
Let me ask you this question. Are you asserting that each of the parents individually are to be assessed on their ability of reunification efforts and not be lumped together?
Yeah, I mean, I do believe that. I think that the evidence and the prior findings, the history of the case is very supportive of respondent mother. Respondent father is not a party to the appeal, and he could have appealed the order, but chose not to. So I think at this point, respondent mother has to be treated individually. And what she's done, I mean, the respondent father he wasn't completely out of compliance with the case plan. He was fully he was engaged fairly significantly, but he's not a party to the appeal. So I think respondent mother has to be treated separately.
Thank you.
And let me ask you a follow-up. In the record or in the order, many of the items here seem related to poverty and being in a lower economic class, related to her job, related to what she can and can't get done, being able to keep a job or having to change jobs. What impact, if any, does the fact that some of these findings of fact and conclusions of law seem to be based on the mother's poverty impact whether we should uphold this order or not?
Well, I think that, particularly focusing on the day of the hearing when the mother testified that she was going to be moving and that she had to obtain housing, tended to seek her own independent housing, and her finances and economics situation are clearly an issue. And I think it underscores her need, given everything else that she had done. And she was employed throughout most of this case. I mean, there's a finding in the court order that employment stability was an issue for her, but because she had 3 jobs in 3 years, and I would say, given a lot of these cases, she had fairly stable employment. Yes, she changed employment a few times, but I think it underscores her need for reunification efforts. I mean, this was a moment where she clearly needed some effort or some help from the department to fulfill her case plan and the need that she had for particularly for suitable housing.
And just to clarify your position, just so I'm clear, it's not that the plan should have changed to giving custody back to the mother immediately at this hearing. It's that we just shouldn't have, or the trial court shouldn't have stopped reunification efforts with your client, correct?
That's right. I wanted to, unless there's another question or two, I wanted to address the trial court's findings in the order that we're addressing the requirements of section 7B 906.2D. These findings, the cases of this court have held, these findings are relevant to the issue of whether reunification should remain as either a primary or secondary permanent plan. So at the initial permanency planning hearing, the trial court made these findings. This was October of 2017, and found that respondent parents were making adequate progress to achieve reunification, were actively participating in the reunification plan, were remaining available to DSS, the guardian ad litem, and the court, and were not acting in a manner inconsistent with their daughter's health and safety. And those same findings were repeated in the permanency planning hearing on March 8th of 2018. And 3 out of 4 of them were repeated again in the first permanency planning hearing that dealt with both children, Corey and Kaylee. At that point, and we do have this in the brief, but at that point, the court found for the first time that the parents were acting in a manner inconsistent with the health and safety of their children. But there wasn't really, it wasn't clear from the reports of either the guardian ad litem or the department what had actually changed to justify that one change in finding, other than the passage of time. And then by the time we get to the order at issue here, these findings were all changed around so that now the parents were not making adequate progress within a reasonable time, were not actively participating or cooperating with the permanent plan, the department, or the guardian ad litem, and were acting in a manner inconsistent with the health and safety of the juveniles. And as we mentioned in our reply brief, the inconsistency between these findings in this order and the corresponding findings in the prior orders raises the question, what had really changed to justify the changes in the findings? And it appears that very little had changed except the passage of time. And both the social worker and the guardian ad litem testified. I think it's a fair assessment or statement of their testimony. So they both highlighted the passage of time and the need for permanency as the reason for changing or requesting that reunification be stopped. So we do not believe that when a mother is complying with her case plan requirements, demonstrating the ability to care for her children in both supervised and unsupervised visitation, that the passage of time alone can justify a trial court eliminating reunification as a permanent plan or ceasing reunification efforts.
And looking at record page 275, to your point there, at least some of that passage of time is attributable to DSS, correct? They made a motion on January 31st to continue this matter out into February. Because they chose to call other cases earlier that day instead of this case.
Yeah, there were a number of continuances. I mean, on the the younger child's case, there were probably 4 at least continuances of the and continuations of the non-secure order before disposition was ever reached. So, and it is true, a lot of them were lack of court time.
And to that extent, with other continuances other than this one here at 275, which is clearly DSS, were the others joint motions or were they DSS motions?
I think that there were a combination of things. I'd have to go back and review those. A number of them were lack of court time. I think that trial counsel was maybe not available for at one point, but there were, I think, more than one that were DSS motions for lack of court time.
And as far as we know, there was nothing barring DSS from calling these cases first on those days, correct? At least in our record?
Nothing that I'm aware of, no, Your Honor.
Thank you.
So we don't, following up on these findings that were made per section 906.7b, 906.2d, the findings in the subject order don't really correspond to the actual historical record or to the facts as of the date of the hearing. Things really had not substantively changed since the earlier findings had been made, and the findings are simply not supported by the evidentiary findings of fact or by competent evidence. Because
our
yes.
considerations under 906.2d, is that part of the court's abuse of discretion that we should be reviewing court's decisions on weighing those factors as abuse of discretion, or do you contend that that is subject to a slightly lower standard in supporting the conclusions?
Well, clearly in a permanency planning hearing, the findings of fact, conclusions of law have to be supported by the findings of fact, and the findings of fact have to be supported by competent evidence. So I think the best way to review this is are these findings supported by competent evidence? Are they in fact inconsistent with evidentiary findings in the same order, evidentiary findings in prior orders, and are they supported by the evidence that was before the court at the time of the hearing? So I think that, you know, just probably in closing, unless there's more questions, because of the history of the case, the evidence at the time of the hearing, and the court's evidentiary findings of fact, the evidence and the evidentiary findings didn't support the ultimate findings of fact that were required, that reunification efforts would clearly be unsuccessful or inconsistent with the children's health or safety and need for a permanent home within a reasonable period of time. The appellees argue that the totality of the evidence and circumstances supports the findings and the decision of the trial court, but we would submit that looking at all of the evidence, the case as a whole, all of the findings that were made, the DSS statements in their report, that the totality of the evidence does not support those adverse findings and does not support the required findings of fact, and actually supports the one finding that we've emphasized at the beginning, that the respondent mother was compliant with her case plan, compliant with the department's recommendations, and had exhibited the ability to care for her children during both supervised and unsupervised visits. And the other point that we made in the reply brief is that the trial court's continuing sanction of unsupervised visitation amounted to a continuing finding that the respondent or the children were safe in their mother's care per the section that we cited in our reply brief. So with that, unless there are any more questions, I think I don't have any more to say without really repeating myself.
Mr. Dypenbrook, you have about 6 minutes left that we can hold that for any rebuttal that you'd like to have. That would, if that's like us to do.
Yeah, I think I would like to do that unless the court has any further questions at this time.
Okay. Judge Murphy, Judge Hampson, either one of y'all have further questions?
Not right now.
Okay. All right.
Same right now.
Okay, thank you. We will reserve the remaining 5 minutes, 54 seconds for any rebuttal you might like to have. Okay? Thank you. Thank you.
Thank you very much.
Thank you. We'll hear from the appellee. Deal. Y'all have some agreement as to dividing your time, or which one?
Yes, Your Honor. I will be speaking for 15 minutes, the first 15, and then Ms. Lynch will use the last 15. And we have talked about how we'll be addressing the arguments as well.
Are y'all splitting up the issues, or y'all covering both?
We are planning on splitting up the issues, understanding Your Honors may have questions for us, and we understand that as well.
Okay. All right. Well, anything further before we start?
No, Your Honor.
Then, you may proceed. Thank you.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Jim Dill, and I'm the attorney for the appellee, Cumberland County Department of Social Services. Today, I will use the first 15 minutes to address what is in appellant respondent mother's argument, whether there's competent evidence in the record to support the 906.2D findings at the February 2019 PPR hearing, and why might the February 2019 PPR 906.2D findings be different as compared to previous orders. Ms. Lynch will be addressing the issue of 906.2B and the whether it's contrary to the health or safety of the juvenile and competent evidence and prior orders as well. Getting to the prior orders, when you look at this case, and it's a little bit complex and convoluted, we start in 2016 with Corey being taken into care. From 2016 up until about 2018, looking through the facts, the respondent mother is able to hold a part-time job. She's able to hold that consistent job until February 2018. On top of that, the father is also allegedly holding a consistent job through labor ready force. When it comes to the residents, they're in the same residence from December 2016 to February 2018. They have the same residence. So under the disposition order that was entered back in 2017, where it said stable housing, stable employment, the maintaining financial obligations, during that course, they seem to be doing those 3 things, along with, and we will openly admit, working their services, which is a great thing. And I want to applaud my client because it's noted on the record on appeal, I believe on page 105, that even the court notes that despite what has gone on in respondent father's past, the department still wishes to reunify with his family. So the department tried to do this. This occurs up until about February 2018. When we get to the March 2018 order, which is a dispositional hearing, in the second child's case, Kaylee, you start to see a change at that point. What happens is now the parents have gone to a different housing situation. On top of that, what's being reported is that they had issues with furniture, that their housing was cluttered. It was unorganized. It lacked heat.
Why does that matter for if a kid is going to be in a safe environment if the house is cluttered, unless there's a fire hazard or they don't have enough furniture? I have rooms in my house that are bare of furniture. So, I mean, why does that matter for considering reunification with a child?
Well, Your Honor, it comes to the stability of the home and the condition of the home. It was reported
well, at least the furniture reflects somebody's poverty or their economic level. an amount of clutter may reflect that they just like to stack a lot of stuff around. If I turn my camera around in my office, you'd probably think it's pretty cluttered too. So I'm just trying to see why these things relate to what's happening here on reunification.
When you have
Come up with a million paper cuts, but none of them add up to this isn't a safe environment for the child, that they've been unfit. So I see you can get each little line, but what do those have to do with the whole point of the system the legislature has created here?
Well, Your Honor, and that's a very good question. And at that point, if you'll note, the court does not cease reunification efforts. The department reports the concern, but the court doesn't say we're ceasing reunification efforts. So that was not the basis to cease in the February hearing. What we're noting is that you start to see a little bit of a turn. That's what we're noting. There's a little bit of a
turn in terms of the child's relationship with the mother, correct? There was no turn in her ability to parent or her ability to conduct these supervised and unsupervised visitations.
We will agree with that. We will agree with that, Your Honor. Individually, no. And we will agree all the way up and through the February hearing. We know that she herself individually does not have the issue in terms of visiting with the kids, seeing the kids. We understand that, and we acknowledge that openly. But when you get all the way up to the February hearing, I guess what changes is it's not just the condition of the home. It's in essence, when you look at the transcript, no plan for a home at all going forward. Meaning when mom testifies, she says, I'm going to move, but she has no identifiable address. She has no lease to provide. She has nothing to provide the court with. On top of that, what you notice in terms of the employment, and I understand the argument on poverty, we would argue this is not a poverty case. When I think of poverty, I might think of food stamps, or I might think of housing assistance. This is not one of those.
People that are employed 40 to 60 hours a week that are still impoverished.
I understand, Your Honor. Well, and I understand. We are not looking at it as a poverty case. What we're looking at is a question of stability of employment, as the court ordered back in February, of stability of employment. And what you've got over time, if you go back to the September 2018 hearing, which is the first time you ever find acting inconsistent, that is the first time it's both parents are unemployed. Up until that time, you don't have any employment issues. But come September 2018, now we have unemployment. Then we go from the September hearing up into the February hearing, where there's no plan for housing. Essentially, we would argue homelessness. And how that relates to a child's safety is, we agree mom has been able to visit with these kids, and she's done a great job individually. And I'll be open, my client struggled, because as Your Honors asked, do you treat these people together, or do you treat them individually? We treated them individually. That was the plan. The issue for us
the case plan always treated them together, correct? The case plan never changed from trying to reunite as a family unit. And that's what
I apologize.
Guided towards, correct?
I apologize, Your Honor. I didn't hear the whole question.
You said the department was treating them individually, but if my memory of the case plan and the prior orders is, everything was to reunify as a family unit, not reunify with mother, not reunify with dad. It was always family unit, family counseling, these attachment counselings, this growth as a family unit. So is there any point before February of 2019 that DSS was treating her differently? Or had a different actual case plan or parts of the court orders that applied to her differently than the family unit?
No, the goal was always to reunite them as a family unit. That was the goal. I guess when I say treating them individually, I mean when it comes to the ceasing of the reunification efforts in February. When you look at that order, what you tend to note, and what you will note, is the court's main concern with dad is what's happened in the past, and that he can't take care of these children. And that's his visitation issue. Now, dad also has the issues of the housing, the employment, but the big one is his interaction with the kids. Mom, and we argue the totality of the evidence here, because what you've got is a mother who, unfortunately, She had done a great job making wonderful decisions up and until about the summer of 2018. But come the fall of 2018, we started seeing issues in terms of her decision making when it came to employment and housing. And what you end up with is
there anything
where
showing
is
those
that
are
in the
her
order?
decisions? Sorry, go ahead, Judge Hampson. I apologize.
No, I apologize. Where is all that in the order that we're reviewing? What I see in that order as it relates to respondent mother is that she's gone in the prior order unemployed.
correct.
By the time of this hearing, had found employment again. So that's an improvement. The finding is that individually she is compliant with the case plan. She is all it's appropriate, etc. Obviously, the target of this order here is is respondent father. But the problem, I think, comes in. I think this is where your colleague is getting to, is that at some point in this order, around about finding 22, 23, the trial court all of a sudden starts, instead of referring to an individual, starts referring to the parent simply as respondents. That's what leads to the kind of the inconsistencies in this order. You know, making findings that the respondents, plural, are actively participating or cooperating with the permanent plan of reunification. But that, you know, that finding is not entirely accurate, as I think you somewhat agree with here, in that respondent mother is, in fact, part in that process. And the other part, I guess I would raise, and I'll just let you address all of this, but you know, as you said before, the whole point of this was sort of reunification of the family unit with both respondent father and respondent mother. It strikes me that when at the hearing, it becomes obvious that the real concern here is respondent father and his ability, parent ability. You know, it seems quite reasonable then that respondent mother, having never been part of the plan before to separate from father, but once it becomes clear that's a concern, she's simply making the effort to say, if that's what it takes, yes, I will obtain, you know, independent housing, which has never been required by part. You know, individual. So it kind of goes back to the point I was asking Mr. Edenbrod. I mean, was the option here simply for the trial court to say, you know, unification with father is off the table at this point, but let's continue reunification efforts with respect to respondent mother. We'll conduct another review hearing, you know, and see how it's progressing. Was that an option, or was the trial court simply limited to dealing with both respondent parents, as it did in finding 23 on, as just, you know, in the totality? Sorry, you can address any or all of that as you see fit.
I will try. I will try, Your Honor. You're breaking up on me a little bit, but I will try. The first thing is that was an option. That was an option. I would make the argument, though, that under Chapter 7B as a whole, the polar star is always achieving permanence as quickly as you can for a child. The department had been involved with this family quite some time, for over 2 years. The court had ordered the employment, the housing, the financial stability. And after 2 years of working with her, unfortunately, she had those previously. She didn't have those then. So to continue on and say, we're going to predominantly focus on reunification means, okay, we're going to try and focus on mom. But what we're going to have to wait is she's going to have to probably come back for another hearing in 3-6 months, tell us she then has housing. Then we're going to have to wait another 3 or 6 months to see if we can do a trial home visit. Then we may be waiting another 3 months to make sure everything's okay. Whereas the court that day set the plan as guardianship, custody with other suitable persons. Understand that the testimony basically said the current placements were going to be long-term placements. The juveniles had both been there over a year. They were willing to take custody or guardianship, and they were willing to facilitate visitation for the parents. Understand that's the testimony, along with what the court found. And in those findings, I will Note to the court that the mother hasn't appealed any of the other findings other than I think it's 23 and 24 in the subject order. So all those other findings are binding on mom. She didn't erase them in her brief. And some of those findings deal with inconsistent employment. Some of those findings deal with the housing issue. You also deal with the visitation issue. Based on those things, the court then found with mom and these other findings, again, the housing, the inconsistent employment, and the inability to financially maintain, she was acting inconsistent. And based on that, she then is found under 706.2D to be acting inconsistent. We couple dad in there and the fact that, yes, this is a credibility question. I think Judge Murphy asked that. The judge was looking at credibility. All the way back in the record on appeal on page 5, there's an allegation, the very first petition that got filed in December of 2016, that mom and dad already indicated dad's leaving the house. There's in the reports indicating that mom hid Corey's pregnancy, that mom didn't get prenatal care. Then when she shows up, and yes, in January, it was a motion to continue by the department, but the department did inform the parents in January 2019 we'd be asking for relief. When they come 30 to 45 days later, and they know that they need to get these things in place, they still don't have them in place.
But there wasn't any change to the case plan even up until February to say that she needs to move out. Is there something I'm missing in the record or the DSS report that saying mom has to move out and be on her own?
You're asking what the underlying question is, which is, did she really know this or not? And I will say in the record, there is not, other than in the transcript. When you look at the transcript, mom's attorney, actually mom did this. When she calls her own client, mom's attorney says to mom, you understand dad's been the issue the whole time. And she says, yes. You understand dad's the reason you can't have your kids back. And she says, yes. And so through that line of questioning, it becomes apparent to the court that she's kind of known that the whole time through that line of questioning. I will acknowledge there's no order that says
put anybody into, a huge catch-22. If I do what DSS is saying behind our back, they're going to come back and say I was trying not to support the family unit and I was not trying to help my husband or my boyfriend come along and be a better father. When DSS is saying this and not putting it in writing, not getting it as part of a court order, but it's what they secretly want, and they're not trying to tell the trial judge or trying to tell the trial court.
And I don't think it was secretly what we wanted. I think when you look at the record, the fact that both parents originally failed parenting classes. Dad was dismissed from the first parenting class because he missed 2 sessions. We had to wait it out till 2018 and give them an opportunity to complete all the intensive parenting. And then because they completed at the end of July, and we had our next hearing only 1 month later, and we really hadn't had a decent amount of time to watch and observe and see if they learned things, the department still wanted to reunify with both to give them that chance and observe it and see if they learn tools from those services. So from that standpoint, the department never really wanted to do that. That was not the department's goal. So in a nutshell, I would say at the end of the day, when you look at this case, there were changes, particularly in 2018, when it came to employment, housing, and we end up in February with, unfortunately, a mother who, by her own testimony, says she does not have any planned place to go. She has no address, but she is leaving her home. A mother who, through her own testimony, said that she could basically barely afford rent for herself, and failing to comply with those 3 disposition orders, along with dad who's in there, who's failed to comply with medication management for the last 5 to 4 months, and who also honestly just can't take care of the kids. The department has to be relieved. And when you look at the court's order, considering all the testimony, all the evidence, the time that was spent, and the department recognizing the constitutional rights of families, the department ceased reunification efforts with the mom. We'd ask the court to affirm the February order. Thank you.
Given the different options in terms of ceasing reunification or primary and secondary plan, it's been about 5 years since I was in a DSS courtroom. So just correct me if I'm wrong on my interpretation of the statute. Couldn't DSS have suggested that reunification become a secondary plan and have a new primary plan that you're working towards in case mom doesn't get this housing that she's talking about. Why isn't that the proper alternative the court should have been looking at, even if it felt there were problems with the housing?
Your Honor,
reunification to a secondary plan.
right. Looking at the statute, I think based on a strict reading of the statute, it doesn't say, well, if you can just keep reunification and do it. It talks about inconsistent with the safety or health. And I think based on the employment and the housing, that's the way the court ruled. So we just asked the court to affirm that order. Thank you, Your Honor.
Thank you.
Okay, Mr. Deal, before you go, I have one question.
Yes, sir.
I'm going to give a couple extra minutes, so Ms. Lynch will have, you're right now about 11 and a half minutes. But
Thank you, Your Honor.
this was February of 19. I just a general question: how is DSS dealing with the fact that kids are home, classes are canceled, there's limitations on work, people are out of work? Just a general question: what are we going to be seeing a year from now as a result of people can't go to work, kids can't go to school, people out of work can't work? How are you dealing with that as far as compliance plans?
Your Honor, I believe we all recognize here in Cumberland County, virtual schooling, it's what's going on. And you read all the headlines in terms of failing grades, the percentages. I think we have to recognize that.
Yeah,
And we have to recognize that parents are doing the best job they can. I think about single moms. I mean, how hard that would be working. I think the department's taking that into recognition. Back in 2019, we did not have COVID or the pandemic. But I think going through this year, the department is recognizing that, especially when it comes to services and service providers. Service providers.
Classes, they're not classes being held, or if they are held, they're being held virtually. And we don't know there's technology available for these parents if they're already poor to be able to attend classes virtually. So I'm just anticipating that we're going to see a lot of issues.
Well, my hope would be that even if we see issues, that we understand the constitutional rights of families, we work with them, and we do everything we can to keep families together. And that would be my hope. And I think that's my client's hope too. One good sign I will say with service providers is we did see, I think, down here in Cumberland County, maybe about a 3 or 4 month time where they weren't doing the services. They just kind of closed. But they have opened back up to do the virtual, to try and do the social distancing, to do the substance abuse, to do the counseling, whether it's virtual or in person. They're trying to do those things. But I think going forward, speaking on behalf of my client, our hope is that everyone gets back to where they need to be, but we understand that it may take some time, and we're just going to have to work with families in that light.
Okay, thank you very much. Ms. Lynch, are you the other issue?
May it please the court.
Good afternoon.
Good afternoon. I'm Michelle Formativall Lynch, and I represent the appellee guardian ad litem in this case. I think it's important for us to remember the reason we are here today is for 2 children, sisters named Corey and Kaylee. The fundamental purpose of our juvenile code in North Carolina is to ensure that the best interest of the child is the paramount consideration by the court. When it is safe and in the best interest of a child to return them to the home of their parents, then that is what the court should do. However, a court should never return a child to the home of their parents when the parents have not shown that their home is safe and there is a likelihood that the child will be abused or neglected there. It is our contention that the trial court made the correct decision when it determined that returning Corey and Kaylee to their mother's home would be contrary to their continued health and safety, and that after actually working 4 years with DSS, there was no real progress. Thus, reunification efforts could cease. I do not mention the father's home only because he did not appeal the trial court's ruling. However, the fact that the mother's home is also the father's home and has been since this case started in 2017 is extremely important in this case. After they were born, neither Corey nor Kaylee were in the custody of their mother very long due to the abuse suffered by their older sister, who I will call Ashley. Ashley is also one of the primary reasons we are here today. She was the first child born to the mother and the father. The record shows that when she was 15 weeks old, back in 2015, the mother left Ashley in the care of her father, Mr. Shipman, for about an hour and a half. When the mother returned home, it became obvious to her that Ashley had burns on her body. She had second-degree burns on her leg, her back, and her face, and had to be taken to the burn center at UNC. The Beacon team at UNC determined that the burns could not have been caused by a humidifier, as explained by the parents. It was determined that the burns were caused by non-accidental trauma. And Mr. Shipman later pled guilty to felony child abuse due to the burns suffered by Ashley while in his care. While he pled guilty to felony child abuse, Mr. Shipman has never offered a plausible explanation for how Ashley was burned while in his care. Ashley was adjudicated neglected and abused due to the serious physical injury that she suffered, and her case ended in 2016 when her grandmother became her guardian. Both Ms. Jefferson and Mr. Shipman had a case plan in Ashley's case, but they never completed it. Then Corey was born on November 30th, 2016, and the record shows on page 38 that a social worker early on in this case provided the father the opportunity to leave the home in order for Corey to stay in the home with her mother. But that did not happen. The history of this case shows why Mr. Shipman has never been granted unsupervised visitation. Page
But
35.
it was never ordered, Ms. Lynch, it was never ordered at any point that she not be with the father, correct? It was never part of any case plan whatsoever. Am I wrong on that?
It has never been ordered that he could have unsupervised visitation with any child.
Okay.
It has always been that his visitation must be supervised. I believe even with the mother there. The mother was granted unsupervised visitation, but he has never been granted that.
But there's never been a court order that she shouldn't keep working with the father, correct?
When you say she, you mean the mother?
The mother.
There has never been a finding that she should not work with the father. The case plan and the orders always say that they need to provide stable housing. It does not say that that housing has to be together or apart. It does not specify either way.
Okay. So she was never told that in any case plan or any court order that she needs to get away from the father.
DSS told her that all along. When this first child was born, they told her that if he leaves the home, you can have your child. And also in the record, there is a mistake on record page 281 in the finding number 2, paragraph 22, that she had indicated to DSS back in July of 2018 that she was going to separate from the father. She has known all along that that is the main problem, and she finds it impossible to separate from him. Page 35.
You indicated, I think, something a little different than what DSS is arguing in terms of her never making any real progress. What was real progress to you?
Real progress would mean that the father showed that he could actually be a parent to these children.
What real progress did the mother not make? I'm only asking about the mother. She's the only person that killed this order.
I'm sorry. The mother never showed any progress in separating from the father and being able to provide a safe home for these children, because all of the studies, the DSS, his psychological report, every evaluation by DSS workers who have observed them said that.
Oh, Ms. Lynch, we've lost your feed, at least on my end.
Now?
We lost you for about a minute there.
Okay.
Yes, ma'am.
The progress that the mother cannot make is that as long as the father is in her home and involved, she cannot make progress because he cannot make progress. And
Is that in a case plan or court order? Anywhere in this record?
it does not specifically tell her that she has to leave him, but it is indicated throughout that that is the problem with her providing a stable home for these children. It does not say she has to separate, and it doesn't say she has to stay with him. It is
Other
just
than not leaving the
requirement.
father, is there any other areas that you feel or that the record reflects she did not make real progress on? And
Well,
I would say that, in the hundreds of DSS cases I've read, or at least dozens, since arriving at the court, she seems to have done more progress than at least 90% of them on her plan. So I'm trying to figure out what she did not use real progress, or where we don't see real progress in the record.
Well, on the day of the hearing, when she testified, she did not have a home. The lease in the home she was living in was ending, and she didn't really know where she was going. She essentially was homeless. She said, I may live with my mom. I may live with some friends. She had no idea where she was going to live.
Is that really different, though, than any other parent in economic distress, particularly in the times they've lost their job, they can't pay their rent, they can't work? I mean, how is that different than any other economic situation?
Well, I don't believe the mother ever made poverty an issue in the trial.
Ms. Lynch, I think we've lost you again.
Get your buffering just a minute.
The mother never brought up in the trial court the issue of poverty, that her lack of money prevented her from doing anything. So since she did not bring up poverty, I don't believe that issue is even before the court. It was never argued to the trial court. It wasn't argued by the mother in her brief.
So the fact that she's going to move but cannot identify the exact place at a certain time, is that fatal, or is that a problem?
I think that's a real problem, because she knew a month before that DSS and the guardian ad litem were asking for reunification to cease. She knew that a month ahead of time, if not longer, and she had made no progress in that. Plus, she and the father had told the social worker that they were getting in place together, and she testified that she planned to be apart from him. Also, while she did have 2 part-time jobs, she pretty much admitted she could not take care of the children with the 2 jobs that she had, and she was going to quit one. She only showed that she worked a full-time job.
Doesn't that show she's a good mother and is caring and is seeking out to spend more and more time with her children and make those further sacrifices?
I'm sorry, I didn't get the first part of your question.
Doesn't that cut against basically everything DSS is saying? I mean, the fact that she's looking, she can barely get by as it is. She has, can you hear me now? It's buffering for a second. The fact she can barely get by, she's willing to give up one of these jobs to spend more time with her children. How is that not the whole point of what DSS is trying to do with all these case plans? Isn't that the goal, is to reunite these families, not have some checklist that mom, makes $150 a week versus a $95 or whatever it is? Yep.
My whole system went down for a minute, but let me address this. Yes, the mother never had a problem taking care of her children as far as when she was with them and DSS saw them together. She did have some problems with her housing. She did have some problems, I guess, keeping stable full-time employment. She was only employed full-time for a short while. The main issue here was the father. I mean, that is obvious. If you look through everything about him in this record, there was just no way that DSS ever recommended, or a judge could ever put these children back in a home with this man who's been convicted of felony child abuse and has never shown really any remorse that he has changed in any way, There is.
But again, none of that is in a court order and none of that is in a case plan. How is somebody in a lower economic position, I don't know anything about her educational background, but I'm guessing it's not the best in the world. How is she supposed to suspect what DSS is wanting when the actual written court orders and written case plans say nothing about leaving him and only talk about reuniting the family unit? And their counseling leads them to reunite as a family unit.
I don't remember it being that counseling led them to be together. I know it is in the court orders, everything about the father, and the father had issues and the father could never be left unsupervised with the children. So I guess you got that being said, and the mother's also being told you've got to provide a safe and stable home for these children. So there is a little, I guess, convergence between you have a father here that can't be left alone with your children, but you're supposed to find a safe home. Well, how do you do that? Well, I guess common sense would tell her she's got to separate from the father, because he can't be left alone with the children.
Ms. Lynch, that's kind of where my problem is. I want to be clear here. I don't think anybody's questioning whether DSS should be involved with this family based on the underlying allegations and adjudication. I don't think anybody's questioning or arguing that these children should be immediately returned to their parents under any circumstances. The question becomes, in particular, is respondent mother sufficiently progressing such that reunification efforts should continue? And what I hear you arguing is that essentially she's not progressing and is not compliant with DSS recommendations. What I'm struggling with is that seems directly inconsistent with the trial court finding in finding 21 that the respondent mother has been compliant with the department's recommendations. And so I'm having a hard time squaring those things. And I know you're well up against your time, and thank you for addressing our questions, and thank you, Judge Tyson, for the additional time. But if you could kind of speak to that, how do we square those two seemingly inconsistent positions?
Did you hear Judge Hampson's question, Michelle? Ms. Lynch?
I think I heard it. And you mentioned finding number 21, and when the court said that she had been compliant with the department's recommendations. And that finding, it does say she's exhibited an ability to care for the juveniles during supervised and unsupervised visitations, but then it goes on to about the father, that he really has not. And I think that one finding does not mean that overall she has made progress in all areas. I think that one finding talks about, yes, there's never been a problem with her taking care of her children. That has never really been an issue in this case. The issue is other parts of their case plan. I know it has been brought up about poverty, although it's never been shown that she argued that in the trial court, and it wasn't brought up in her brief on appeal. One part of the case plan is that they were to submit a budgeting worksheet to show that what they could do or couldn't do so DSS could help them. There's nothing in the record to show that that was done. I don't think that was mentioned that they ever did that.
Wouldn't finding of fact 21 say that she did, though? If we read what the trial court found, the respondent mother has been compliant with the department's recommendations. Doesn't that include completing the budgeting worksheets?
I don't believe it does. It didn't say that specifically. The main thing that finding mentions is that she has the ability to care for her children.
Well, that may be the theme of the sentence, but if we take the trial court's words there in that first sentence, they say she's been compliant with the recommendations.
They do say that, but it does not say she has complied with all of her case plan. She had been compliant with some recommendations, But then you go on to 22, it talks about that they reside in the same home, and that had to be a misprint because July 2019 had not happened. That back in July, 6 or 7 months before, she said that she intended to get her own place. And then it talks about in the hearing, she says she does not have a definitive address or lease to provide to the court. So 21, I think overall, she had been compliant and tried to work with DSS and their recommendations, but I don't think that first sentence in finding 21 indicates that she had complied with every part of her case plan and had fulfilled every goal of her case plan.
Ms. Lynch, I'll give you a moment to sum up.
While the mother in this case admittedly cares for her children and takes care of them when they are with her, the fact remains that she appears to be incapable of separating and maintaining a safe and stable home apart from the father. By the time of the February 2019 hearing, she had been involved with DSS really for 4 years in the cases of Ashley, Corey, and Kaylee. Ms. Jeffcoat could not show she had a safe and stable home for her children or that there was any possibility of one happening within a reasonable time. She did not show that she could separate from Mr. Shipman, who had a conviction for felony child abuse, and he never improved to the point he could be left alone with the children. Based on all the evidence, the trial court did not err in concluding that reunification efforts should cease. It was clear that reunification would be contrary to the children's health and safety. An abuse of discretion is manifested if a trial court's ruling is so arbitrary that it could not have been the result of a reasoned decision. The trial court's ruling in this case is not arbitrary. It is clearly the result of a reasoned decision. We ask that you affirm the order of the trial court. Thank you.
Thank you, Ms. Lynch. Thank you very much. Mr. Diepenbrock, a rebuttal?
Thank you, Your Honor. Your Honors, I think it's impossible to square finding 21 that respondent mother had been compliant with the department's recommendations and that she had shown this ability to take care of her children during supervised and unsupervised visitation with the findings that the statute requires in order to eliminate reunification as either a primary or secondary plan or to cease reunification efforts, that such efforts be clearly unsuccessful, inconsistent with the health and safety of the children, and inconsistent with their need for a permanent home within a reasonable period of time. The trial court actually did not make those specific findings. They did have the findings needed or required by section 906.2D, but the findings that reunification efforts would clearly be unsuccessful, etc., were never actually made. What the court did say, that I think the closest place is in finding 24, that says the court finds that a plan of reunification with respondent mother and respondent father is no longer appropriate, is in fact contrary to the continued health and safety of the juveniles. Respondent parents have failed to demonstrate they are capable of providing a safe environment for the juveniles, and the court no longer has any other alternative than to relieve the Department of reunification efforts. The court will do so at today's hearing. The respondent parents object to the relief of reunification efforts. So in our brief, we didn't take issue with the failure of the court to make the more specific findings that the statute describes, but I wanted to point out just address the fact the trial court said it had no other alternative other than to cease reunification efforts and to eliminate reunification. There were other alternatives, and I think that this has come up during the questioning from your honors. There was an alternative to give the parents more time. There was an alternative to give respondent mother specifically more time. Reunification could have been a secondary plan. And reunification could have been, the court could have ordered DSS to pursue reunification efforts with respondent mother by herself. And those were all alternatives. And the fact that respondent mother was having housing issues at the day of the hearing really underscores the need for continued reunification efforts, because in light of everything else that she had done, that the department acknowledged in their reports throughout the history of the case, and then court made corresponding findings, particularly finding 21 in the last order. In light of her efforts, further reunification efforts and support was clearly warranted to help her find housing, independent housing, and help her with employment. Now, she was employed. She was holding down 2 jobs at the time of the hearing. So I don't think that we didn't challenge other evidentiary findings, because they really didn't support the findings that the court made, didn't support the ultimate finding of fact or conclusion that reunification was no longer appropriate. When your honors were asking Ms. Lynch about, well, what was the failure to make, what was respondent mother's specific failure to make progress, and she said more than once it was a failure to separate from respondent father. But the court, as Judge Murphy pointed out and brought out, the court never ordered that, and the department's reports never indicate that they had instructed or strongly recommended respondent mother to separate from respondent father if she was going to be able to reunify with her children. So another alternative at the time of the hearing would have been for the court to say, you're going to have to separate from respondent father. You're going to have to do that if you want to reunify with your children, and we're going to give you an opportunity to do that, and the department is going to help you as much as they can to find independent housing and make it work. So, and I don't think respondent mother had to say poverty is an issue for poverty to be an issue. Poverty was an issue. She was struggling, but she was working. She was doing everything she could, and she spent a lot of time engaging in visitation, I think 2 or 3 days a week, and engaging in parenting classes and services. I think she was doing everything she could, and it was premature and really contrary to the statute and the statutory framework to completely cease reunification efforts and eliminate reunification as a plan at that time. So thank you for your consideration.
Judge Murphy, you have any further questions?
I don't, Judge Tyson. Thank you.
Judge Hampson, you have any further questions?
No, thank you.
Okay, well then, without further questions, the case is submitted. We would like to thank counsel for appearing today, and particularly on this special setting, and for the arguments. And without further ado then, Mr. Sewell, will you please adjourn court?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you.
Thank you.